This case can be viewed.
What is your name?
I'm Zach Jernigan, excuse me, sorry.
Sorry.
Zach Jernigan, I'm in for Attorney Burdine.
Go ahead, I'm sorry.
This case can be viewed in two different ways. It can be viewed as a sad, tragic case with Miss Otarski's the mother of the minor child. Consistent use, that is illegal use, habitual drunkenness, selling of those illegal car wrecks, and extramarital affairs that have destroyed a family. Or it can be viewed as a story of resilience, where despite what has happened, despite what the minor child has been through, she and the father have created and established an extremely tight bond that through this last year, year and a half and beyond, where they've had to deal with Ms. Otarski's inappropriate marital conduct, they have been able to establish a bond that has made them closer, but has also made the minor child safer. It is in the best interest of the minor child to remain under the father's care and only the father's care. The mother has consistently come back into the daughter's life and then is left again. She has been in and out of rehab, but she has been unable to remain a consistent parent to the minor child. And while you can look at this case either through the lens of the first scenario, that it's a sad, tragic case that has destroyed a family, or the second lens, where it's a story of resilience that has made a bond between the father and the daughter extremely close, either way, there is no doubt that it is in the best interest of the minor child to be with a father that has cared for her, that has taken care of her, than to be in the mother's care that has put her in horrible situations. Thank you.
So Otarski, you're representing yourself in this case. You have the right to make an opening statement. Opening statements are not evidence. They're simply the opportunity to let the court know what your position is regarding the issues in the case. Do you want to make any sort of statement? I'm going to give you a chance to testify, but this is whether or not you want to make an opening statement.
I don't think that's necessary.
Right. You may call your first witness, Mr. Jernigan.
Good morning, Ms. Otarski.
Morning.
Would you admit that you have put your minor child in bad situations, whether it be because of your use, drunkenness, car wrecks, or any and all of the above?
I do admit that, yes.
Pull that microphone to the base towards you. Pull the base of that microphone towards you so that it'll make sure it picks up. All right.
I do.
Do you admit that within the last year, the daughter has been in Mr. Otarski's care?
Yes.
Do you believe that has been over that past year in the best interest of your daughter?
Yes.
Nothing further, Your Honor.
All right, ma'am, you can step down. You may call your next witness.
I call Mr. Otarski to the stand.
Mr. Otarski, if you'll come around,
Mr.
please.
Otarski, you heard me in my opening statement discuss the various inappropriate marital conduct that Ms. Otarski inhibited during the years of your marriage. Can you please describe this habitual drunkenness, illegal use, the car wrecks, and how that affected the minor child?
Yes. Over a span of years, especially the past 2 to 3 years, Morgan, my wife, has shown, like you had said earlier, there was multiple times of use. There was multiple times of marital affairs with other men. There were multiple times of her getting in car wrecks that could have possibly put our daughter's life in danger. Luckily, it didn't. Yes.
And then how can you describe how things have changed and how things have been better, I guess, over the past year when Ms. Sotarski has not been around?
During the last little bit when Morgan was around before her first stint to rehab, and after that, when she was gone for about 3 months, our daughter was very quiet and very timid and wasn't really talking to anybody. And over the past year or so, a little over a year, our daughter has opened up. She has been very happy, very doing well in school, no complaints or anything like that. I have recently got her an intake into a therapist, just to if there's anything that she needed to talk about, but beyond that, she's been doing good.
And then lastly, you said first stint in rehab. How many times has Ms. Sotarski been to rehab? When you say first stint in rehab, does that mean that she went back? Was it unsuccessful the first time?
In the past 2 years, a year and a half, has been twice.
Okay. Thank you.
You have any questions? Don't leave it. You have any questions you want to ask him? I'm going to give you a chance to testify, but this is an opportunity, acting as your own lawyer, for you to question him about things. Do you have any questions? Okay, I do. You have a house, is that correct?
Yes, sir.
Part of what I have to do is to make an equitable or fair division of the property that you and she have acquired. According to the file, you acquired that house before your marriage?
It was it was before we got married, while we were still together.
You were together, but you were not married when you acquired the house?
Yes, sir.
Did you have to pay money down on that house?
No, sir, not that I can remember.
You didn't make a down payment on it?
No, sir.
What about during the course of the marriage? How were the payments made?
I made the payments.
Right. But that was out of funds that you and she acquired during your marriage from your employment?
From my employment. Yes.
Okay. And your filings with the court have indicated that hold on a second. That the house had a fair market value now of $292,000 and an outstanding balance due on the mortgage of $185,000. So there's been equity that's increased during the course of your marriage, correct?
Yes, sir.
Now, my simple calculations are that that's about $107,000 in equity right now. Would you agree with that?
Yes, sir.
All right. In your pleadings, you have stated you ought to be awarded the marital residence because you have been responsible for $1,600 in credit card debt, $4,000 in a loan that you took out prior to filing for divorce to cover insurance deductible, and $4,500 for purchase of a bed in a marital residence. And I'm assuming you still have that bed?
I do, and I'm still paying it off.
Right. It's a nice bed for $4,500. Is it one of those electronic ones?
Yes, sir.
So that comes to about $10,100 in debt that you're saying that you are going to have to assume her part of, right?
Yes, sir.
So $5,500 of that marital debt would be attributable to her, but you're asking to offset $53,500 in equity in that marital home against a $5,500 debt. Does that seem fair to you? You understand what I'm saying?
Yes, I do.
She doesn't have a lawyer. My job is not to represent her. My job is to make an equitable division, which means a fair division of the marital property. Now, she's been gone from home for how long?
About 2.5 years.
A year and a half, okay. And during that year and a half, you've been solely responsible for upkeep or support of your child, correct?
Yes, sir.
All right. So she hasn't paid any child support in that year and a half? Correct?
No, sir.
All right. Do you know if she's employed right now?
I believe she is, yes.
Do you know, has she been paying anything in the last, since you found out she's been employed?
No, sir.
All right. Secondly, how were these rehabs that she went into, how were they paid for?
I believe through my insurance that
Your
she was
insurance
on.
payment.
Yes.
Did you all have to pay out of pocket for that?
I'm not entirely sure if there was any out of pocket. She has been dealing with that.
In addition to that being awarded all of the equity in the house, you're also asking in your pleadings, that it wasn't brought out in your direct examination, but you're asking that you be awarded all of the personal property in a marital residence, including furniture, appliances, television, kitchen items, linens, lawn equipment, lawn furniture, tools, and the child's personal property. So basically, she would get her personal effects, and that's it, according to what you were saying.
Yes, sir. There's a couple items that belong to her family, but beyond that, yes.
All right. Thank you. You can step down. Sure. Jernigan, you have any other witnesses?
I do not, Your Honor.
Ms. Otarski, this is your chance to testify. You want to come up and have an opportunity to be heard about what you want to do about the parenting plan and the property division. Come around, and we're going to ask you to raise your right hand. I think she was sworn in before that. Ms. Otarski, this is your opportunity as your own witness to testify. The first thing I'm going to ask you, I gather from what was said earlier, that you don't dispute the fact that he might be entitled to a divorce.
No, I don't.
All right. The second thing is the parenting plan that they have proposed is providing that he be the primary residential parent and that you have supervised visitation with the child, but that you have to undergo drug testing to be able to see your child. Do you understand that to be the case?
I do understand that.
And do you have any opposition to that parenting plan?
I do.
All right, tell me what you're asking.
All I'm asking is weekends, unsupervised, with provided trains.
So you want to provide a drug screen, and then if your drug screen is clean, then you want to have unsupervised visitation on the weekends.
Yes.
All right. And how old is your child?
10.
10 years old. All right. What was the nature of the problem? I know you were in California in a rehabilitation at one problem.
Yes. I tried my recovery since last February. I left in the beginning of February. He said 1.5 years. It's exactly a year from in a couple of weeks that I've been gone. So I thought that I was obligated to get back home after when I finished to finish this divorce off. It turns out that I was not ready to get home. I needed more time in treatment, and I relapsed. I relapsed the week of my first daughter's death anniversary.
Your first daughter's death?
Anniversary, yes, sir.
Okay. Tell me about that.
My first daughter, Lily, died of cancer in 2019.
Was that your daughter with Mr. Otarski?
No.
This is a child you had before?
Yes, sir.
And she died of cancer?
Yes, sir.
Sorry to have to discuss those situations, but when did that occur?
2019.
And how old was your daughter?
She was 11.
Okay.
My addiction spiraled down from there. And ultimately, it ruined my marriage. It ruined my life, the way I parented. I know the consequences that I face. But I needed more treatment, more than just 45 days. And I realized that when I woke up in the hospital in September of last year. So I went back to treatment. That's
What
my
was the
second.
drug choice that you were using at that point?
At that time, it was Adderall and Ativan, which was given to me by a therapist because of my grief. And I knew that there was a script waiting for me when I got home that's been dangling above my head for months, but I didn't succumb to it until my daughter's death anniversary, and I relapsed. I went back to treatment, and I stayed for 45 plus 90 days. 45 in treatment, 90 days outpatient.
Are you in any sort of outpatient treatment right now?
I am
following?
not. I completed everything. I'm doing 90 and 90 by my own will, 90 meetings in 90 days at this moment. I've gotten a sponsor. I've gotten a job.
Are you going to NA or AA or what?
Both.
Okay.
Yeah. And I was hired since, I believe, 2 weeks ago. So I've been employed for 2 weeks
Where are you working?
at Massa Staffing, which is, they provide factory work in Monogram Foods
Where are you living?
with my grandmother and on Newsom Drive in Dixon.
All right, so you're living with your grandmother and you're now gainfully employed and you're attending regular meetings.
I am.
All right. And anything else? Tell me about this house. When it was bought prior to the marriage, tends to make it, if it's only in his name, his separate property, but the increase in value that occurs can be considered to be marital property. During the marriage, were you working?
I was working. However, I was only providing income for myself and for my car note. He was right when he said that all mortgage was paid on his note.
But it was paid out of his wages during the marriage.
Yes,
And you and he were married in 2019 and then you separated in 2022.
that's right.
So that would be a 3-year marriage essentially, correct?
I do know one thing is that he kept our taxes to himself the year that I left to treatment. And also he kept my insurance money that I was going to use for a car to pay for a lawyer.
Do you have items of property, furniture, furnishings, and things that you're asking to be awarded out of the house?
I got everything that I wanted.
Or you don't want any of the rest of the property? All right. Anything else that you want to tell me about this?
I believe I covered everything.
All right, Mr. Jernigan, you have any questions based on what she's testified?
Yes, I do, Your Honor. You said you were in and out of rehab. How long have you been out of rehab?
I came home February 8th. I don't know which times you're talking about.
I'm sorry, the second time.
I came home on February 8th.
And the first time you went to rehab, how long were you out of rehab before you went back?
For about 5 months, I believe. I came home in March, came back in October.
So,
Relapsed in September, but been clean beforehand.
so you've been out of rehab this second time for less than 3 weeks?
That's right.
I'm really sorry to hear about the traumatic event that you were talking about with your other child. Are you concerned that if you had another traumatic event that you could fall back into that same cycle?
I'm not. I have a sponsor. We utilize sponsors for that.
Did you have a sponsor the first time when you came out of
I
rehab?
did not.
Would you say that if you did fall into that same cycle like you did after the first stint in rehab, would that endanger the minor child?
I know that if I relapsed again, it wouldn't help her at all. No.
And you discussed bills during the marriage. You said you paid just the car note, is that correct?
That's correct.
You brought up taxes.
Mm.
Is it true that you had an agreement with Mr. Otarski that because he was covering all the bills, that he should get that tax return that year?
No, it was agreed that we'd share the taxes together and split. I don't know about the splitting part, but sharing, yes. I never agreed that he could keep it, no.
Did you state that Mr. Otarski paid the mortgage every time and you have not contributed to any utilities or any other bills besides the car note?
That's right.
Nothing further, thank you, Your Honor.
What are you making currently in your income?
17 an hour.
17 an hour?
Yes, sir.
You work 40 hours a week?
Yes, sir.
You have insurance available through your work?
I will have insurance after 90 days.
Okay. Will your daughter be able to be covered under that?
I believe so, yeah.
All right. Thank you. You may step down.
One more thing, can I ask? Can I be provided like some kind of file that we had court today so I can show it my boss?
They can give you a note that
Thank you.
clerk can give you a note that shows that you were here in court. So, all right, thank you. All right. Do you have any other witnesses, Ms. Otarski?
No, I don't.
Attorney, you wish to be, you want to call any rebuttal proof? Let me call your client back to the stand just for one purpose, and that's to establish his income. You show on your proposed parenting plan he makes $5,000 a month, and I just want him to just affirm that whatever it is under oath. Mr. Otarski, I'm calling you just because my obligation is to determine your income for purposes of calculating child support. Where are you working?
I work at Jim and Nick's Barbecue in Nashville.
Okay, and what do you make as far as your income there?
I make $60,000 a year
So
annually.
that equates to $5,000 a month. And do you have your daughter covered under insurance?
I do.
All right. Okay, thank you. That's all I needed. Just step down. I'll hear you in final argument if you wish to make a closing statement.
I do, Your Honor. In closing, I believe it's most important and will show truly what is in the best interest of the minor child by reviewing the best interest factors of TCA 36-6106. First, strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of the parenting responsibilities relating to the daily needs of the child. This factor clearly weighs in Mr. Tarski's favor as he's performed nearly all of the daily responsibilities and care for the child over the past year. Number two, each parent's or caregiver's past and potential for future performance of parenting responsibilities. This factor, again, weighs clearly in Mr. Otarski's favor as he, over the past year, has been the primary caretaker of the minor child. Number three, refusal to attend a court-ordered parent education seminar. This, again, weighs in Mr. Otarski's favor as he is the only one who has attended the parent education seminar, showing his willingness and readiness to be the primary parent and caregiver of the minor child. Number four, the disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. Again, Mr. Otarski has been the only parent providing all of these items, food, clothing, etc. for the minor child. Number 5, the degree to which a parent has been the primary caregiver. Again, Mr. Otarski has been the primary caregiver while Ms. Otarski has been in rehab. Number 6, the love, affection, and emotional ties existing between each parent and the child. While I have no doubt that Ms. Otarski loves her child, Mr. Otarski has been the one that has been showing that love over the last year, caring for her, taking her through her daily needs, whether it's school, medical care, any and all of the above. Number 7, the emotional needs and development level of the child. I believe this factor is extremely important. Mr. Otarski has not been taking any drugs. He has been primarily caring for the child. And with a child that is born in 2013, and this is an extremely important area of a child's life where they're going into their teenage years, and being around even the possibility of or anything of that nature could be detrimental to the child and could change the child's entire course of their life. Number 8, the moral, physical, mental, and emotional fitness of each parent as it relates to their ability to parent the child. Here, Mr. Otarski has shown over the last year that he is more physically, mentally, and emotionally fit to care for the child. While I do not doubt that it can be extremely hard to lose a child, Mr. Otarski has battled through that loss, continuing to care for the child without resorting to alcohol, extramarital affairs, or any of the above. Number 9, child's interactions and interrelationships with siblings, other relatives, step-relatives. Mr. Otarski has shown through his parenting plan that he is willing to allow the minor child, he knows it's in the minor child's best interest to have a relationship with the maternal parents of Ms. Otarski through his parenting plan that has shown in the supervised visitation section that he encourages the minor child to be a part of the maternal parents' lives. Number 10, the importance of continuity in the child's life and the length of time the child has lived in a stable, satisfactory environment.
All right. This court finds that the plaintiff in the case, Mr. Otarski, has proven grounds for divorce, and he'll be awarded a divorce on the grounds of inappropriate marital conduct. The court is required to make an equitable or fair division of the personal property and real property that's acquired during the marriage. And by statute, the increase in value of separately owned property would be considered to be marital property so long as both parties contributed to it by prevailing or by showing that they had participated in the marriage as a husband and wife and fulfilled their duties. Up until Ms. Otarski became emotionally devastated by the loss of her daughter, this court finds that she fulfilled her duties and obligations as a wife. And as a result of that, up until that time, she certainly contributed her part to the increase in value. The fact that they were that marital residence was paid for by the husband with his wages does not change the nature of the fact that those wages are marital property, and as a result, he has contributed marital assets to the increase in value of that property. And I'll address that in a minute. The court finds that the value of the property has increased $107,000, that is the equity in the property that exists right now, and there's no other proof to combat that. That would mean that each one of them, if it was equally divided, would have $53,500 in marital property. Mr. Otarski, through his counsel, has proposed that he retain all $107,000 of that property based upon the fact that he's having to pay $10,100 in debt, half of which would be attributed to her. So if you deducted that $5,500 from $53,500. That would leave you with approximately $48,000 in equity that Mrs. Otarski would still potentially, theoretically, be entitled to. The 18 months that she has been out of the home and without paying any sort of child support, if you take the figures, which according to the proof before me today is accurate, that her income would be $2,500 and his would be $5,000, then she would have a child support obligation of about $410 a month, and that 18 months would equate to $3,280, and roughly rounding that down to about $45,000 in remaining equity that she might be entitled to. At this point, the court is of the opinion that perhaps the simplest way to allow Mrs. Otarski to try to get back on her feet would be to offset any claims that she has for equity in the marital residence against a child support obligation, which would be about $410 a month, for approximately $4,000. And if you did $410 a month for a 12-month period, it would come to about $4,820 per year, which would equate to approximately 10 years as an offset of $45,000. However, the division of marital property is not required to be completely equal. So it's this court's opinion that her child support obligation should be suspended and offset against her interest in the marital real property for a period of 5 years. That means for 5 years, she will not pay child support based upon the fact that she is offsetting that against her equity in the marital residence. She says she has all of the items that she wants out of the house, so he'll be awarded all remaining personal property, household goods, furniture, and furnishing. As I've offset those claims that he might have for reimbursement of debt against her equity in the house, the court is of the opinion that he would be responsible for the payment of those debts. Moving then to the parenting plan, the court is of the opinion that I can tell you, I can't imagine what it would be like to lose a child under those circumstances, to have an 11-year-old child die of cancer. I've had friends die of cancer, and it's a terrible situation, a terrible disease. So I can only imagine how traumatic it must have been. That doesn't excuse the behavior that resulted, but it certainly seems to understand. I can understand how it happened. Mrs. Otarski, by the proof before me, has taken steps to right the problems in her life, and she is currently in remission, or by what I can tell, seems to have her life straightened out. She's going to NA and AA meetings for 90 meetings in 90 days, and this court will order that she continue that as a part of this parenting plan. She'll continue outpatient treatment through either NA or AA on a regular basis. And that would mean at least 2 times per week that she would attend those meetings. Secondly, I don't see a need for supervised visitation in view of that fact. And so as a result, Mr. Otarski, I've reviewed all of those factors that are set forth in the statute. Mr. Otarski meets all of the criteria to be the primary residential parent. There's no question. I don't think she even contests that at the present time. So Mr. Otarski is going to be the primary residential parent for the child. You'll be responsible for that. I'm going to give her unsupervised visitation, but I'm going to grant your request, as you put in your parenting plan, that she has to submit to you monthly 12-panel meetings. And if she submits a drawing that is positive, then you have a right to immediately suspend her visitation and appear in court for a contempt motion. So Otarski, that means that the burden's on you to get that monthly. And I would say you just at the first of each month, you go, and we're almost at March the 1st, you need to go take one right now.
Today's case dives straight into a family torn apart by addiction, grief, and resilience. Meet the key players: Mr. Otarski, the father who has stepped up for his daughter through unimaginable circumstances, and Ms. Otarski, the mother battling personal demons and addiction. Over the next hour, you'll see tragedy, legal strategy, and emotional tension collide in a courtroom showdown. Will the judge side with stability or risk? Who truly has the child's best interest at heart? Stay tuned as we break down every shocking moment, every revelation, and the decisions that could change a child's life forever. Right off the bat, the judge frames this case in two ways, either as a tragic failure of parenting, or a story of resilience. The father clearly has a strong bond with his child, established over the past year despite the mother's repeated absences. Notice how the court immediately contrasts her instability, rehabs, relapses, and risky behavior with the father's consistent care. That sets the tone. In family law, consistency and safety often outweigh intentions and emotions. Audience question here: do you think past mistakes should completely block a parent from custody, or is recovery enough to earn back trust? Here's where the court gets precise, reviewing 10 key factors from the TCA 36-6-106 statute. Each factor, from primary caregiving to emotional fitness, tilts in favor of Mr. Otarski. Notice the judge's strategic precision. Unsupervised visitation is conditional, tied to monthly drug tests, ensuring accountability. This isn't a punishment, it's a controlled path for the mother to rebuild trust. The court also cleverly offsets child support against property equity, offering a financial path to recovery. This is family law at its most sophisticated, balancing compassion, caution, and child protection. Question for viewers: could you see yourself following such strict visitation conditions, or would it feel punitive? In the end, the verdict is clear: the father retains primary custody, ensuring the child's safety and stability, while the mother is granted a conditional opportunity to regain trust. Family court isn't about punishment, it's about protection, accountability, and structured redemption. Recovery is possible, but patterns matter more than promises. The financial and parenting decisions reflect fairness, compassion, and strategic legal reasoning. If you found this case as shocking and thought-provoking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Every case has lessons, let's dissect them together.